Good evening and welcome. It is time once again for CU Immigration here on WRFU LP Urbana, 104.5 FM and UPTV. I will be your host for this evening. My name is Mr. Garza, and I am here to let you know that WRFU is an open forum for the Urbana-Champaign community. Views expressed are those of the speakers and are not intended to represent WRFU or UCIMC, or, as we like to say on this version of the show, UPTV. These views are our own, and by our in this instance, I mean myself and anyone whose opinions I may happen to be reading through the course of my look at the news that's going on. So, having said that, I think today's show is going to be dedicated to the United States Government Accountability Office Report to Congressional Requesters, Immigration, Information on Deferred Action for Childhood Arrivals. It's a new report out by the GAO, and I thought it might be interesting to viewers to listen to what this thing is all about. So why did GAO do this study? Well, in June 2012, DHS established the DACA initiative. Under DACA, DHS has the discretion to provide temporary protection from removal from the U.S. or deferred action for certain non-citizens who came to the U.S. before the age of 16. DACA recipients are neither granted lawful immigration status nor put on a pathway to lawful status. Rather, they are considered to be lawfully present in the U.S. during the 2-year period of deferred action. USCIS has granted DACA to more than 800,000 non-citizens. In July 2021, a federal court ruled that USCIS may not approve first-time DACA requests, but temporarily permitted USCIS to continue to approve renewals of previously approved requests. GAO was asked to review the extent to which USCIS shares information on DACA requesters and recipients with immigration enforcement agencies. This report describes the circumstances under which USCIS shares information on DACA requesters with immigration enforcement agencies and how CBP and ICE have applied DHS's immigration enforcement priorities to DACA recipients and those who may have potentially qualified for DACA since 2012. GAO analyzed USCIS, CBP, and ICE policies and guidance, analyzed USCIS data on adjudication outcomes and the circumstances under which USCIS shared information on DACA requesters with ICE from June 2012 through June 2021, and interviewed relevant headquarters and field offices. Stepping aside for a second, when DACA first came out, and we were in the business, we being CU Immigration Forum, in the business of helping people get signed up and giving them advice and information and all that sort of thing, I was asked by a lot of people, is this a good idea? And it was probably the hardest question I ever had to answer because I didn't have a good answer for it. And to this day, I have in hindsight, I have a better perspective on it. But I think now if I were transported back in time with what I know now and been asked that question then, I still would have a little bit of a hard time answering it. Because obviously, when you sign up for DACA, you're giving them a lot of information. By them, I mean the government. And what they do with it, there are rules, there are regulations, there are, all sorts of things that constrain their use of it. But at the same time, they have it. And I suspect if they really want to get at it, if anybody in the government, any group really wants to get at it, they probably can in some way. And that makes you very vulnerable and your family members very vulnerable. So while it has proven to be a great thing for a lot of people and really helped them out, I would still, if I were signing up today, if I were a potential DACA applier and I were signing up today, I would still be really unsure if it was a good idea. So this report should be interesting in the sense that it should tell us a bit about how this information gets around and how it's been used so far. So we'll see. A synopsis, what GAO found. In 2012, U.S. Citizenship and Immigration Services, or USCIS, published guidance explaining that it would not proactively provide information from Deferred Action for Childhood Arrivals requests to immigration enforcement agencies for the purpose of immigration enforcement, unless the DACA requester met certain criteria. For example, USCIS may refer certain DACA cases to U.S. Immigration and Customs Enforcement, ICE, for a possible criminal investigation if the requester represents a potentially public safety risk based on the individual's criminal history or to identify fraudulent claims. USCIS, I'm going to mispronounce that a bunch of times because I'm lazy and I don't like saying it. USCIS has shared information with ICE for immigration enforcement purposes on a small number of DACA requesters and recipients who engaged in activities that disqualified them from DACA. Specifically, of the 106,000 DACA requests that USCIS denied, it referred fewer than 900 cases, less than 1%, to ICE. Since 2012, U.S. Customs and Border Protection, CBP, and ICE enforcement practices related to DACA recipients and individuals who might qualify for DACA have generally aligned with the Department of Homeland Security's immigration enforcement priorities. While DHS's immigration enforcement priorities have varied since 2012, the department has generally not considered DACA recipients to be immigration enforcement priorities unless they met specific criteria, such as having engaged in certain types of fraud or activities that posed a threat to national security or public safety. While DACA recipients are to be provided temporary protection from removal, individuals who might qualify to receive DACA but who have not yet submitted a request or are awaiting approval do not have such protection. However, CBP and ICE officials stated that they have generally extended prosecutorial discretion considerations to individuals who may have potentially qualified for DACA as long as they had not engaged in activities that would disqualify them from a favorable exercise of such discretion. Boy, there's lots of little, you notice these little verbal loopholes in here. Oh, man. Okay. So they give themselves a way out a lot. All right. Okay, so this starts with a letter from the Honorable Gerald Nadler, Chairman, Committee of the Judiciary, House of Representatives. In June 2012. Oh, wait, this just goes back over the same stuff. Okay, never mind. We will not read that. We'll just go on from there. Well, I guess we kind of have to because it sort of describes how they did things. All right. Okay, so we already read why they did this, and this first two paragraphs reiterate that same information. Okay, you have asked us to review the extent to which USCIS shares information on DACA requesters and recipients with immigration enforcement agencies and for what purpose. This report describes the circumstances under which USCIS shares information on DACA requesters with immigration enforcement agencies, and how CBP and ICE have applied DHS's immigration enforcement priorities since 2012 to DACA recipients and those who may have potentially qualified for DACA. To address our first objective, we analyzed USCIS documentation, including DACA request forms, policy memos, guidance documents, standard operating procedures, and training materials. These describe the information USCIS collects and uses to adjudicate DACA requests and may share with immigration enforcement agencies during the adjudication process. Further, we analyzed DHS-wide policies on information sharing, as well as CBP and ICE documentation describing the nature of their respective access to USCIS databases containing information on DACA requesters and recipients. In addition, we analyzed USCIS summary level data from DACA's inception in June 2012 through June 2021, the most recent available data during the period of our review. Specifically, we analyzed USCIS data to determine adjudication outcomes, as well as the circumstances under which USCIS shared information on DACA requesters with immigration enforcement agencies, particularly ICE. To assess the reliability of these data, we reviewed them for reasonableness, accuracy, and consistency. We also interviewed USCIS officials responsible for maintaining the relevant data systems about the steps they took to ensure the quality and reliability of these data. We determined these data were sufficiently reliable to describe the outcomes, e.g. approvals and denials, of initial DACA requests and renewals and the number of DACA-related cases USCIS referred to ICE due to national security, public safety, or fraud concerns. Further, we interviewed headquarters officials from USCIS's Service Center Operations Directorate, which is responsible for overseeing DACA adjudications at 4 of USCIS's 5 service centers nationwide. We also interviewed USCIS officers at the Nebraska Service Center, including those from the center's background check unit. We interviewed headquarters officials from USCIS's Fraud Detection and National Security Directorate, which is responsible for investigating potential immigration benefit fraud. We also interviewed officials from the ICE headquarters office that receives referrals from USCIS for potential investigation on suspected cases of fraud or national security and public safety concerns. To address our second objective, we analyzed agency documentation, including executive orders, DHS policy memos, CBP and ICE memorandums, and guidance documents on DHS's enforcement priorities. We analyzed CBP and ICE policies and guidance documents governing encounters with DACA requesters and recipients, including those who might qualify for deferred action. We also analyzed DHS and USCIS documentation on CBP's and ICE's access to and use of USCIS databases to verify the immigration status of non-citizens encountered at the border and interior checkpoints. Such documentation included privacy impact assessments and user guides for each data system. We interviewed CBP and ICE headquarters officials to obtain their perspectives on agency policies and practices related to encounters with individuals who potentially qualified for, had requested, or had received DACA under various immigration enforcement priorities since DACA's inception in 2012. We also interviewed USCIS, CBP, and ICE headquarters officials to discuss CBP and ICE access to and use of USCIS databases containing information on DACA requesters and recipients. Okay, I'm going to skip a lot of this stuff here. It's just going over and over and the same thing. Okay, background. We kind of know this stuff, but let's just go over it again for the sake of reminder. To be considered for initial grant of DACA, non-citizens must establish through documentation that they arrived in the U.S. before age 16, were age 30 or younger, and had no legal immigration status on June 15, 2012, have continuously resided in the U.S. since June 15, 2007, up to the date of filing, were physically present in the U.S. on June 15, 2012, and at the time of the DACA request, are in school, graduated from school, or have obtained a certificate of completion from high school, or have discharged under honorable conditions from the military, and have not been convicted of a felony, significant misdemeanor, or 3 or more misdemeanors that do not otherwise pose a threat to national security or public safety. To be considered for DACA renewal, recipients must establish through documentation that they did not depart the U.S. on or after August 15, 2012 without advance parole, and have continuously resided in the U.S. since receiving their approval for DACA and have not been convicted of felony, significant misdemeanor, 3 or more misdemeanors, and do not otherwise pose a threat to national security or public safety. Okay. According to USCIS officials, USCIS retains the discretion to determine whether deferred action is appropriate in any given case, even if these guidelines are met. There's their way out here. USCIS defines deferred action as a type of prosecutorial discretion that allows an individual to remain in the U.S. for a set period, unless the deferred action is terminated. Prosecutorial discretion is the long-standing authority of an agency to decide where to focus its resources and how to enforce the law against an individual. We have previously reported that due to limited resources, DHS cannot respond to all immigration violations or remove all individuals who are determined to be in the U.S. without lawful immigration status. Therefore, DHS has exercised prosecutorial discretion in the enforcement of the law. Current and prior administrations have developed various priorities for the enforcement of civil immigration laws, as well as for the exercise of prosecutorial discretion. Since the creation of DACA, legal challenges and evolving administration priorities have affected non-citizens' access to DACA. In June 2012, DHS issued a memorandum establishing DACA. In September 2017, DHS issued a memorandum rescinding DACA and directed USCIS to stop accepting initial requests and providing a limited time frame for accepting renewal requests. This prompted legal challenges resulting in a series of California and New York federal district court rulings throughout 2018 requiring DHS to continue accepting DACA renewal requests but not initial requests. In June 2020, the Supreme Court held that the September 2017 rescission of DACA was invalid, thereby keeping DACA in place. In July 2020, DHS directed USCIS to reduce the period of deferred action and related employment authorization from 2 years to 1 year, and not to grant advance parole, absent exceptional circumstances. In December 2020, following a New York Federal District Court ruling that directed DHS to take a number of actions, including posting a public notice that it would be accepting first-time requests for DACA, USCIS resumed accepting initial DACA requests and granting deferred action and related employment authorization for a period of 2 years. In July 2021, following a Texas Federal District Court ruling, USCIS may accept but no longer approve initial DACA requests and may temporarily continue approving renewals of previously approved requests. Most recently, in September 2021, DHS published a notice of proposed rulemaking for DACA, which reinforces that DACA recipients should not be a priority for removal. It's convoluted. Okay, I'm going to skip over the agency's roles and responsibilities. Well, no, I won't. I'll read that too, because that's something that I think a lot of people, you hear these acronyms, ICE, USCIS, DHS, and so on, and it's helpful to review what these different agencies do. Okay, so USCIS. USCIS service centers are responsible for adjudicating DACA requests. USCIS officers at the service centers adjudicate DACA requests by determining whether requesters meet established DACA guidelines. USCIS's Fraud Detection and National Security Directorate, or the FDNS, is responsible for researching and verifying information related to fraud concerns. Within USCIS's service centers, officers are to refer requests with fraud-related concerns to FDNS's Center Fraud Detection Operations, fraud detection units, for resolution. Also, within the service centers, the background check unit is responsible for reviewing and resolving any criminal, national security, or public safety concerns identified by comparing DACA requesters' information against law enforcement databases. USCIS is also generally responsible for issuing notices to appear for cases, including DACA requests with substantiated findings of immigration fraud. ICE. ICE agents and officers are responsible for identifying, apprehending, detaining, litigating charges of removability against, and removing non-citizens who are in the U.S. in violation of U.S. immigration law. ICE's Homeland Security Investigations is responsible for conducting criminal investigations to prevent unauthorized non-citizens from obtaining fraudulent identity documents and immigration benefits. ICE's enforcement and removal operations conducts civil immigration enforcement actions, which includes administrative arrests, detentions, and removals. In addition to arresting non-citizens for administrative violations of immigration law, it also conducts criminal arrests and assists with prosecutions related to such criminal activity. ICE is also responsible for issuing notices to appear, including those based on public safety and national security concerns related to DACA requesters and recipients. ICE officials stated they may encounter DACA recipients during routine immigration enforcement operations, and that non-citizens who are already in ICE custody may sometimes self-identify as potentially qualified for DACA. Okay, the CBP. Within CBP, Border Patrol is responsible for securing U.S. borders and apprehending individuals arriving at the borders between U.S. ports of entry. Also within CBP, Office of Field Operations is responsible for inspecting travelers and cargo seeking to enter the U.S. through ports of entry and encounters individuals determined to be inadmissible to the country. Regarding DACA, for example, Border Patrol officials may encounter DACA recipients or individuals who may qualify for DACA at interior immigration checkpoints. Okay, well, all right. DACA adjudication outcomes. Since 2012, USCIS has approved more than 3 million DACA requests and denied nearly 106,000 DACA requests. Of these, more than 800,000 were initial requests and nearly 2.2 million were requests for renewal. While USCIS has historically approved most DACA requests, multiple factors may result in USCIS denying a DACA request. For example, USCIS may deny a DACA request based on indications of criminality or fraud. Criminal offenses associated with DACA denials include non-egregious criminality, such as driving-related offenses, immigration-related offenses, drug-related offenses, theft, and assault, among other offenses. According to a 2019 USCIS report, egregious public safety offenses include, among other offenses, murder, rape, and sexual abuse of a minor. USCIS may also deny a DACA request on the basis of administrative reasons, such as the abandonment of a request, multiple failures to appear for an appointment to collect biometric information, or failure to respond to a request for evidence or a notice of intent to deny a request, according to USCIS's standard operating procedures. USCIS also may deny a request if it finds a requester responsible to a request for evidence or notice of intent to deny is not sufficient to establish that the requester meets the guidelines for DACA. Okay. So, USCIS uses information from DACA requesters and law enforcement databases to adjudicate requests. USCIS uses information and documentation collected from DACA requesters, along with information contained in various law enforcement databases to adjudicate requests. According to USCIS's standard operating procedures, DACA requesters are to establish by a preponderance of the evidence that they meet the criteria for deferred action. Under this standard, requesters must demonstrate that it is more likely than not that they meet the qualification guidelines. Adjudication decisions are based on the sufficiency of the evidence provided. For example, to meet the evidence standard for the education criteria, requesters may provide documentation showing that they are currently in school or have graduated or obtained a certificate of completion from a U.S. high school, college, or university. Further, to demonstrate that they were present in the U.S. on June 15, 2012, requesters may provide employment records such as pay stubs or tax returns, receipts. How about receipts? Yes, such as utility bills or rent receipts, school records such as transcript, script, or report card, or medical records according to the standard operating procedures. In addition, USCIS officers conduct background and security checks against law enforcement databases, including those owned by immigration enforcement agencies such as CBP and ICE, to determine whether requesters have criminal records that would disqualify them from being qualified. Somebody really wrote that in a sentence? That would disqualify them from being qualified. People are getting paid to write this stuff, you know. As part of the adjudication process, USCIS officers may contact law enforcement agencies, such as ICE or CBP, for example, to resolve questions related to a DACA requester who is a positive match to a record in a database. USCIS officials stated that, generally, when their agency contacts ICE or CBP regarding a record match to a DACA requester, the individual is already known, and USCIS is not disclosing new information. For example, they said that USCIS officers may determine through the background and security check process that a record in a database indicates that a DACA requester is potentially associated with a criminal gang. USCIS officers may need additional information about the record to adjudicate a DACA request, which ICE may be able to access and provide to the adjudicating officers. In such cases, USCIS officials stated that USCIS would provide ICE or CBP with sufficient biographical information on the DACA requesters to confirm the individual's identity and obtain the information necessary to continue with adjudication. In addition, a record in a law enforcement database may indicate there is an open investigation involving a DACA requester. In such cases, USCIS, I'm getting so tired of saying that. I wish there were, it's not like DACA or ICE, USCIS, that just doesn't sound right. Okay. I wish there was a way to say it. USCIS. No. In such cases, USCIS officials may reach out to an investigating agency, such as ICE, to ensure that an adjudicative decision on the DACA request would not negatively affect the ongoing investigation. Specifically, USCIS adjudicators may seek information from the investigating agency to determine whether the information is likely to result in the arrest of a requester or whether investigators have obtained additional derogatory information on the requester.